Welcome to our discussion this morning. We're going to give it just a minute for everyone to get loaded into the system. So if you're joining us today, thank you for taking the time. We have a really great discussion teed up for this morning. Okay, I'm going to go ahead and get started. Thank you again for joining us. It's great to have Cindy Effinger with us. She is with McBrayer Law Firm, a great friend of the Chamber, and has been very helpful in navigating the pandemic and some of the big questions that we're getting from businesses since this started back in March. I'm Kate Shanks. I'm Vice President of Public Affairs for the Kentucky Chamber of Commerce. We started our Restart Kentucky webinar at the start of the pandemic as a way to educate businesses and keep you informed about the ever-changing landscape, new regulations, new requirements, and to talk about issues that businesses were struggling with. And it's been a very successful program. I certainly want to thank our partners in this, the Kentucky Community and Technical College System, for supporting our efforts and joining with us as part of some of these discussions as well. If you're new to these discussions and to this webinar, I want to encourage you to visit our Restart Kentucky website. You can go to kychamber.com and click on the Restart banner at the top of the page. Really great resources, everything you need to know about Healthy at Work, the reopening schedule, if something has changed in that schedule. And then we post a recording of all of our webinars on that page. We've done over, I think, 24 at this point. So there's really great content, really great discussion with a lot of, I think, familiar faces from around Kentucky that you'll see on a variety of topics. So please take the time to visit that page. We will be recording this webinar, so if you need to step away for a minute or you need to come back and revisit part of the discussion, that should be up later today. And if you're joining us live, you can chat your specific questions to us in the chat box that you should see at the bottom of your screen. And so as we're discussing, I'll try to monitor that chat box, and you might have some specific questions that we don't ask or that I don't ask that you want to have brought up. So please take advantage of that resource. So with that, we're going to go ahead and get started. And again, thank you and welcome to Cindy Effinger with McBrayer Law Firm. We appreciate you taking the time to join us today. And I'm going to go ahead and dive on in. One of the reasons why we wanted to set this discussion up today is that the governor recently recommended that schools not reopen, or that they push back their in-person reopening until the end of September. And so we started to get phone calls and questions about how that might trigger leave requirements under the Families First Coronavirus Response Act. This is not a new piece of legislation. This was adopted back in March. And so we've been living under the paid leave requirements of this law for a few months now. But some of the conditions in Kentucky may be creating a situation where you're hearing from employees about taking leave. So with that, Cindy, if you just kind of want to walk us through those requirements first off, and how some of these changes with schools might be triggering that.
Yeah, and thank you again to the Kentucky Chamber for inviting me. I always appreciate the opportunity to work with the Chamber and to speak to the members. I also applaud the Chamber for its efforts getting information out and being not only timely but relevant, because these topics are ever changing for us as lawyers, and it's our job to be on top of it. Businesses are trying to run their business, maintain a healthy workforce, and do their job with regard to their manufacturing or their sales or whatever services they're providing. So I think that the Chamber's efforts here are to be applauded. As a refresher, the Families First Act provides for paid leave in two circumstances. One is paid sick leave, to shorten it for yourself, or if you're caring for someone who is either suspected of having COVID-19 or has COVID-19. And then the second provision is the extended family leave, which allows for individuals to get paid leave or if their child's school or daycare is closed due to a COVID-19 reason. And each one of those provisions has specific requirements. Under the paid sick leave, there are 6 different circumstances that are qualifiers, and those circumstances are fairly specific. Employers have been navigating under this for the past 6 months, and with the rise of cases, they're experiencing more and more unique situations. And we can go through each one of those 6 if people want a refresher on that. But generally speaking, if an individual is suspected to have been exposed to COVID-19 or has those symptoms, they or they're subject to a quarantine order by a state or a governmental or a healthcare provider, then the paid sick leave provisions will kick in, which will allow for the payment of wages capped at $511 per day. For every day that they're off, they get 80 hours of paid sick leave. Once those 80 hours are expired, then an employer can require the individual to use paid time off or use unpaid leave. But a lot of individuals, because of the rise in cases, have already used those 80 hours. And so employers are now being faced with, what do we do when the individuals need the paid leave because they've been exposed or quarantined, and how do we address it? And then that's when the paid time off or the unpaid leave would kick in. The biggest issue right now is that a lot of individuals, working parents, use the extended family leave back in the spring. And it was set up, I believe, to cover the period of the time of the enactment of the legislation through the end of the school year. So those 12 weeks have been fully exhausted. And now in Kentucky, we're faced with schools being closed for at least, I think, 6 or 8 weeks. And these individual parents do not have any more leave. So I think this is causing a lot of internal anxiety and strife, employers not knowing what to do, because they don't have to provide the leave if there's no paid leave left under the Act. If they don't have paid leave under their existing provisions, then what employee would look for unpaid leave? A lot of employers will say, I need somebody here doing this job. What do I do? And so I am cautioning people about what sort of action employers should be taken. Obviously, we don't want to be looked at as retaliating against an individual for taking this leave or for taking the leave in the past. We don't want to run afoul of any other laws, such as the ADA, if it applies to someone who has a disability or disabling condition. And we want to encourage certainly people to stay home with their children and care for their children, but we also have to balance the needs of the business. So the first thing people in business should be doing right now is trying to figure out a way to support working parents. And I'm assuming that we're not in a situation where the working parents are abusing the system. How do we support working parents? Can we provide a flexible work schedule? Can we adjust performance expectations? Some businesses are large enough where they can provide on-site childcare services or have some sort of provision for childcare services that they can assist their employees with this, because that ultimately will help the long-term economic situation and long-term growth of the business and our country. So we've got to think about creative ways. Some employers aren't going to be able to do that, and we'll have to really sit down and discuss on a case-by-case basis whether we can fire or replace this individual because they can't return to work, or whether that's a good idea. So I hope that addresses sort of the summary of where the law as it was enacted and where we are today.
I think so, and I think you bring up a really important point that this continues to create some really difficult decisions for employers, and it's definitely been a challenge. This is a crisis unlike anything we have ever seen, and you have employers that certainly want to be supportive of their employees and that also have productivity requirements and services that they provide as well. So it's definitely been very challenging. One area that we focus a lot on is with small business. And is there any consideration for smaller businesses, and how does that play out?
Yeah, so the small businesses do have an available exemption under the Families First Act, but only for the extended family leave, not for the paid sick leave. So if you're a small business and your employees they didn't have to use the Families First or the extended family leave back in the spring, but they do need it now, you have to consider whether you can apply the exemption. If you have under 50 employees, you're eligible to consider the exemption, but it requires a very narrow set of facts. There are 3 scenarios in which a small business with less than 50 employees can apply the exemption. One is if the financial obligations of providing that paid leave would cause you to cease operating at a minimal capacity. Two would be if the absence of the employee would risk the financial health of the business because that employee has some specialized skill that is needed by the business. And the final potential exemption would be if there aren't enough employees who are ready, willing, and able to work to perform the services offered by the business. Now, if one of these scenarios applies, the business must document it with real-time financial records. So you can't just say, oh, we're financially unable to do this, we're going to apply the exemption, we're not going to grant that leave. You have to capture and retain documents that show that financial hardship in order to justify it, one, if you were sued, or two, if the IRS were to, or any Department of Labor would audit you. So you must contemporaneously keep those records. If you have that proof, then you can exempt the individuals and not offer the leave. But again, we have to really weigh all of the considerations because it's far more than just, whether you're financially able to do it. We also, I have seen at least employers having extreme compassion in the situation and going to great lengths. And I, always applaud employers who are actively involved in trying to find solutions as opposed to just simply saying, nope, we're just not going to do this or we can't do this. So, but that exemption is out there for those small employers.
And you mentioned the records. And so a lot of this is about keeping records. So you're not actually applying to the U.S. Department of Labor for an exemption and an approval. You're essentially kind of self-certifying and then retaining records should they inquire about that, correct?
You're exactly right.
Okay. And we mentioned small businesses, but the act is specific to up to 500, right? So if you have over 500 employees, are you under any other requirement, or are you just in your own set of, regulations?
Yeah, if you have over 500 employees, the Families First Act does not apply to you. And those businesses would only be governed by existing laws such as the FMLA and the ADA when considering leave for individuals who are suffering from a serious medical condition, a disability, or caring for one with a serious medical condition. I do want to mention that there was a case just a week or two ago out of the Southern District of New York, and the provisions of the Families First Act were challenged in that district, and the judge struck down 4 different provisions of the Family First Act, which might have overarching and overextending circumstances that might apply here in Kentucky as well. And I want to give just a little summary with a caution that 1, this case is not yet final because the Department of Labor has not yet appealed it. And 2, we're trying to figure out how the ruling in New York could affect anyone nationwide. So the biggest issue with respect to the New York court order is that under the Families First Act, a healthcare employer can also apply an exemption for both provisions, the paid sick and the extended family leave. But under this court order, it struck down the definition of healthcare provider because it focused on the provider and not the employee. So we're not sure how that's going to bear out. We're not sure what the overarching implications are, but that is something we're keeping an eye on. The other one that I think is important is that it struck down the fact that the Department of Labor FAQs require consent of the employer to take intermittent leave under this act. And so it wasn't required under the act that you give intermittent leave, but if the employer agreed, then that was going to be okay. If the employer didn't agree, then you don't get intermittent leave. This court order strikes that down, which again could have implications across the board for any employer who is covered under the act. There are two other provisions that were struck down. The other one that I think is important is that if the employer did not have work available for the employee, then the employer didn't have to provide the leave. So in that regard, you didn't have to worry about laid off employees or furloughed employees or employees who, there just wasn't enough work for. That provision has been struck down and said that if the leave needs to be prompted by the employee's availability, not the employer's work availability. And again, this could have far-reaching implications. And the last one, I'm keeping my notes here. The documentation. The documentation does not need to be provided in advance of taking the leave. And so that was part of the Department of Labor's recommendations, is that you needed to provide documentations ahead of the leave. You can take the leave and then provide the documentation to support the request for leave. So again, we're keeping our eye on that, and you should see blogs from many law firms and the chamber as well to keep up with that. It's just not yet clear where we are, how that's going to end up being applied.
Yeah, and I think that's a waiting game for us, right? I mean, we're still following the act as is passed, and we will follow this. And of course, there's an end date to all of this, the end of the year. So unless Congress takes further action to extend it or passes something to replace it, you're looking at a December 31st end date for this. And I do want to share too that we have a story up on our news site, kychamberbottomline.com, about all of this, and it also links to a guide that was developed by the U.S. Chamber for Business. So if you want to dive into all sorts of detail about the Families First Act, take a look at our Bottom Line news site. You can find those resources. I'm going to shift gears for a minute and talk a little bit about Healthy at Work. So we did a session with a group of attorneys, and he was with us to talk about liability issues, record keeping, how can employers follow these requirements and also protect themselves, protect their employees. And I wanted to take a minute to kind of revisit that, since we have now been under the Healthy at Work requirements for, I think, a few months now, a couple of months at least. So what are you hearing, Cindy? What are some of the issues, the struggles? What are businesses facing as they are continuing to comply with these requirements?
The biggest issue is leave requirements. People will come in and say, I'm fearful. They'll say, my son was around someone who was tested positive. I think I should quarantine. Do I get paid to quarantine under those circumstances? The CDC guidance changes almost weekly on this. And sometimes the CDC guidance conflicts with our own local health departments. And I've seen that in real life. And so the biggest issues employers are facing is, because there's really no black and white rule, and all the scenarios are different. You can imagine the different types of exposures that people will say they've come in contact with. How do we deal with that? Who's entitled to quarantine? Who's entitled to be paid when they quarantine? We have our travel restrictions that are recommendations under Healthy at Work, that there are states with a 15% positivity rate. So what do we do with employees who go to those states and come back? Are they quarantined? And if they are, would they be subject to the provisions of the act? Because it's not an order. And so they probably are not subject to the provisions of the act if they're quarantined by a rule of the employer. The employer is weighing keeping their employees safe and also keeping their business running. So we've got a series of questions coming in about, what do we do? When are we required to keep people home? When are we not? How do we determine how many days they stay home? What happens when they check their Healthy at Work or their initial self-screen and they have one symptom? What if they have two symptoms? At what time do we keep them home, and for how long do we keep them home? What about if you have someone who doesn't wear a mask all the time? How are we enforcing that? What if you have someone who is fearful that their environment isn't safe, but yet you're following all the governor's Healthy at Work initiative requirements? How do you deal with that person without making them feel uncomfortable for bringing the issues to your attention? Telework issues. Are people actually doing the job? Are they doing the job to our capacity and our expectations? How do we discipline? How do we address those issues? Those are constantly on employers' minds. And all I can say is I get calls daily about, okay, we've got this scenario, what do we do? I'm on my own firm's COVID committee. I'm dealing with those internally as well. And it is certainly something that requires us to review the most relevant guidance on a daily basis to figure out what we're supposed to be doing, how we're supposed to be doing it. And the most important thing that I can recommend is employers to stay up to date on it and keep that line of communication open with their employees and treat each scenario consistently. So if someone has to stay home because they have a family member who was around someone who tested positive, then the next person, no matter how key they are to your organization, no matter how much they need to be on site, treat them the exact same way as you treated the first person.
It seems like some of these HR principles, treating everyone the same way, it seems like what we have been learning with other issues apply here. Record keeping, consistency, You mentioned the guidelines and the CDC. Is there a source that you typically go to? I mean, are we simply tracking the CDC on a lot of this? I was looking at it, recently about how long a quarantine period has to be. If you live with someone and you isolate versus you live with someone and you can't isolate. I mean, there are some pretty specific details about this. Is there any specific resource you suggest?
I say the CDC guidance, and part of the, you opened this with a discussion and hearkening back to our liability questions. We don't know if and when lawsuits are going to start coming in. And it depends obviously on the climate, what's going on, people's damages, people's injuries. But to the extent lawsuits are filed, I want to at least be able to say, look, we went to, everyone deems the CDC the experts. That's where we went. We, in good faith, looked at that and tried to abide by it. Where else are we supposed to go? This is something that we've never had to deal with. So to your point, going back to our traditional employment law principles is the first place to start. And then I do believe I start with the CDC guidance, because I don't think many people can argue that that is a reliable source in this time. And people certainly debate whether they believe the CDC or not, but ultimately down at the bottom line is the CDC is a reliable, consistent source. And if you follow that, you can at least say you made a good faith effort to do your best to follow guidance and keep people safe.
Right. And I do have a question that came in through the chat about an appeals process. If you mentioned sometimes the advice conflicts, do employers have that, or are you sort of just kind of stuck in a situation where you have to comply with your local mandate, or do you have a way to appeal?
I do not believe you have a way to appeal. And even if there were, I think by the time the appeal went through, the quarantine period would be over. So I think you're kind of stuck with what the department or the health department issues. And if you are, I think if you shouldn't, if you're challenging, if you want to challenge it, I think you should bring it through the channels. I don't think that you should expect that you're going to get a response, but I think the more information that the government has, because they're also evaluating this on a daily basis, they're doing the best they can. We can certainly complain and criticize, sitting as armchair quarterbacks, everything that our government officials do. But I think that all of us can agree they're trying to do the right thing. They're trying to do the right thing with the best knowledge they have. So information that's coming in on an advisory level certainly would be helpful. I have seen that firsthand with our governmental officials. They take it, they digest it, and then sometimes you will see changes and they will make modifications as it goes on. So I would encourage you to reach out to try to bring into light information, but don't expect any changes for the initial scenario that you have on your plate.
All right, thank you. It's helpful. And we do have questions coming in. I'm going to let those kind of load, and I'm going to go on to a couple more of my questions, and then we'll circle back to some of the participant questions. So if you're watching live, you can chat with us if you have specific questions, and I think we'll be able to get to them. Let's talk a little bit about liability in schools. That's a new issue. It's come up recently. There's been some correspondence from our legislature on it. Where do we sit on that issue, and how is that maybe factoring into some of this?
So we have a couple of issues with schools. Obviously, we have students and we have teachers. The teachers are employees, and the school system itself is setting the rules and creating the hybrid or in-person learning scenarios. So generally speaking, the schools that are public schools are protected from negligence claims on a theory of sovereign immunity. And so to the extent that sovereign immunity might apply, which I will not bore our listeners with a discussion of sovereign immunity, but to the extent that they are immune from negligence suits, that would prohibit any claim by either a student or a teacher or even a vendor for that matter. The school systems that are private don't have that immunity. And so those school systems need to be well aware of and taking the steps to keep their students and their faculty and their third parties safe. You have teachers who are employees, teachers and facilities managers and administrative staff. The employees might be prohibited from suing a school system, not only from the perspective of immunity, but also a workers' comp claim. Workers' comp is constantly in flux, but generally speaking, if you're injured on the job and that injury is an occupational injury or occupational hazard, then you would only have workers' comp as an available remedy. Again, all of these claims, even if you can get past these hurdles, whether you're a student who would be suing for negligence or a teacher or an employee, you still have to prove you got the virus at the school. That proof is going to be very difficult in a lot of situations. And unfortunately, I do think we'll see it play out in lawsuits. People will, have enough facts that makes it more likely than not that that's where the virus came from for that particular individual who, if unfortunately suffered a devastating injury, would want recourse. And that will end up being played out in the court system, even if ultimately successful by the school system or the school district. That will still be played out and paid for with tax dollars for those defenses. So there are a lot of safeguards in place, but there's still so much unknown that we're not sure how it will ultimately play out. I do stress to people that everyone also has a level of personal responsibility. We expect our school systems, we expect our businesses to take all reasonable steps to keep us safe, but we also have to keep ourselves safe. So if you are in a scenario where you don't believe sending your child to school is the safest option, hopefully you have the option to do online learning. For some parents, that's not an option, right? Because they need to go to work. They don't have to leave, like we talked about in the beginning. And unfortunately, that is a scenario where you have to also exercise your own personal responsibility to make sure your child has the PPE, or you, if the teacher, that you have your own PPE and that you take the steps you need to keep everyone safe. That does not excuse a business's, whether it's a school system or otherwise, obligation to make sure that they are not engaging in willful conduct or gross negligence. But again, we're going to have to see that. We'll see this play out in the court system if and when these lawsuits are filed.
Yeah, thank you. And I will point out that the Kentucky Chamber has been advocating for some liability protections for employers, public and private. We've advocated at the federal level. There has been legislation that's been filed in the Senate. So we've been engaged on that could provide some important protections, as well as at the state level. So we'll continue to be active on this issue. We know it's really important for our members. Any thoughts on policy going forward? I know you're following it as well at the federal level and at the state level. I think you joined me in some of the testimony we gave recently on this. So any thoughts on how important that is for Kentucky?
I think it's extremely important. And I think that businesses need to have their voices heard. So to the extent that businesses can take action to reach out to your legislature, reach out to, if you know someone who's in the lobbying industry, and let your voice be heard. I think that, the governor set up a system where you can petition to have your business open and, lay out your plan. To the extent that there is open communication with the governor's office and the legislature, I encourage businesses to do so, because it's really complicated. People on one side who represent the injured parties will say there are enough safeguards in place and we have this reasonableness standard, so we need to move forward. And we can't, grant this sort of immunity, because then we're worried that businesses will not care and just force people back to work. We have businesses saying, whoa, we don't know what's reasonable. We have these healthy at work guidelines that some of us cannot comply with because of the nature of our business, because they're intentionally vague, because the governor's trying to create a workable system and not have, 18, 19, 25 different policies. And so you've got these competing interests. And I do believe that the legislature should act in some way. Not sure what that needs to look like. I do anticipate and hope that there is a debate on how that will look. But we can't be the sole voice. We need businesses to also reach out. And through the chamber's efforts, I think are absolutely important here as well. I do believe that there needs to be some guidance. We need to debate and take into account all sides to come up with something, because this is not something we've seen before. And just like I mentioned a minute ago, the businesses will bear the cost to figure out what the law is if the legislature doesn't act. Businesses are struggling to stay afloat right now. And if they have to defend a lawsuit that they ultimately win, at what cost will that be? Will they shut down? And to establish that law, where I think the legislature can step in and take advice and counsel and debate it and come up with a system that is workable and takes into account everyone's needs and concerns.
Couldn't have said it better. That was great. Thank you, Cindy. And we do have a campaign running right now. If you follow us on social media, you can kind of scroll through our pages, and we'll put an update on there as well, where you can engage with our federal delegation on this issue. So please take a look at our social media accounts for that, and we'll also provide an opportunity at the state level. Of course, the legislature is not in right now, and they'll be convening in January. And we have seen many states, including Tennessee, recently pass legislation to clarify these issues and provide these protections, with, of course, a carve out for gross negligence and intentional misconduct. And so there are plenty of examples of states that have done it. And in some states, it's been done by executive order. So we would not be the first to provide these expanded protections to employers, public and private, if we did that. So more to come on that. I'm going to go through some of these questions, and we're coming up on the top of the hour, but I do want to make sure everybody gets their questions answered. So back to families first. If an employee is paid 2/3 of their normal wages, can they claim unemployment for the third lost wages?
I actually don't know the answer to that. Unemployment is a mess right now, and so I don't know if unemployment is accepting those claims or not. I wish I knew, but I don't know the answer.
Yeah, we can, if you want to reach out to me on that by email, kshanks@kychamber.com, we can dig around on that for you and see what we can find out. I bet that's pretty tricky though, I'm guessing. Yeah. You may have talked about this, but if an employee has been potentially exposed and has to quarantine, are we required to pay them if they no longer have the FFCRA pay? So I guess they've exhausted their time. So you would not be required under that law, correct?
Yeah, because once they exhaust the 80 hours, they're out. Now you could use PTO or go to unpaid time, but no, you would not be required after the 80 hours are exhausted.
Okay. Should HR have an employee submit a Families First Coronavirus Response Act request form for each instance of leave requested?
Absolutely. That is one way that you document the need to either the tax credit that you would get under the Families First Act, or that you use the money for your PPP loan. It is absolutely essential that each request is documented.
Okay, that's it for now. Well, hold on a second. Okay, so some employers are supplementing the third lost pay with their own PTO. So, okay, there are some creative ways of getting around that.
Yes.
Thank you, Julie, for that. So thank you, Cindy. This has been really helpful. Maybe we'll have you back in the future to talk about this, because this is absolutely something that is evolving. We at the Kentucky Chamber continue to follow all of these issues. I hope that you're following us on social media. Please follow us as well at the kychamberbottomline.com. You can sign up to get our updates from Bottom Line if you want emails in your inbox about all sorts of stories. And we have some additional discussions planned in the works for our Restart Kentucky webinar. So please follow along and you can get updates from us on that. And with that, thank you, Cindy, and thank you to everyone for joining us. And this will be posted online later today. Everyone take care and have a great weekend.
Thank you.
Thank you.